Hello the world, hello the internet, and hello of course to Jason Isaacs. This is Paul Talks Politics. I'm Paul, and today I'm going to be talking about politics, specifically this rather sinister chump up here. My experiments in AI art, rather disturbing. Great to see you all again. As you can see, my eyes are better thanks to the NHS and some steroid cream, so if I'm looking extra hench today, you know exactly why that is. All is well. We are going to be talking about Trump and the latest court decision from the United States. So if that's the sort of thing that interests you, please do hang around, and we'll get into that after the intro. And like and subscribe, tell your friends, let me know if there's anything out there you need me to discuss, and I'll see you for Trump and the 14th Amendment right after the introduction. See you in a minute. Don't touch that dial. And we're back. Now, Trump and the 14th. Strap yourselves in, because this is going to get fairly complicated. And of course, this is an evolving situation. We're coming at you on Friday, just before Christmas. Presumably nothing's going to happen until into the new year. But as soon as that does, things are going to get crazy. So, let's establish what this is not. Okay, this is not related to the federal investigations that are ongoing. Trump obviously reckons he's immune from all of this. If you want a really interesting take on that, I strongly recommend Legal Eagle. I'll link off to that in the description. But this isn't that, so we don't have to worry about that. This is also not any of the many civil lawsuits that are ongoing against Trump at the moment, for which he would also like to be immune. This has nothing to do with the ongoing congressional investigations into Trump. So this is in addition to all of that. So what is it? Well, this is all to do with the 14th Amendment. Now, you'll know this as the Rule of Law Amendment. That's certainly how I teach it. Normally when we're talking about the 14th Amendment, we're looking at due process and equal protection. Now, I've been teaching politics since the days of black and white television, and normally that was about the end. That's as far as we got, really, with the 14th Amendment. Turns out it doesn't stop there. It goes on for several more sections. And the section that we're particularly interested in is this bit. It's the Third Amendment. Now remember, Section 3. These are amendments that were passed in 1865 to 1871 or whatever it was. And these are the Reconstruction Amendments, and they were passed in the aftermath of the Civil War. And the object certainly the object of this particular section was to exclude from office those people who had essentially started the Civil War and lost, those being the Confederates. So there was a specific aim here to rule people out of office, to disbar them effectively. And that's anyone who had engaged in insurrection or rebellion against the same, or given aid or comfort to enemies thereof. The thereof and the same, of course, being the United States. So that's the context that we're looking at, and it appears that certain persons in Colorado decided, and not just Colorado, other states as well, decided that they were going to use this particular clause to take Trump out of the Republican primaries. Now, it's worth mentioning at this point that this is all about the primaries. We're still in we're not even in primary season yet. That really kicks off in March. But what we're looking at here is a bunch of Republicans, 4 Republicans to independents, who decided that they didn't want Trump on the ballot, that it was going to take votes away from their preferred representatives. And so they sought to use this particular case to disbar Trump from the primaries. And again, always worth remembering that your important cases here are driven by individuals, yes, but usually supported by pressure groups. That's where the money comes from, that's where the impetus comes from. And this particular pressure group, Citizens for Responsibility and Ethics in Washington, is behind this particular case. Now, behind every great case, you will find a pressure group, whether it's Plessy versus Ferguson, whether it's Roe v. Wade, or even Dobbs versus Jackson. There's always a pressure group in there that's providing the cash and the impetus for that particular undertaking. So this was first heard in the district court. Now remember, you've got courts, you've got that fractal system where the model is repeated on ever smaller scale, and this was in the district court. And in the district court they decided that the events on the 6th of January were or amounted to an insurrection, also that Trump was engaged in that insurrection, The court specifically rejected a First Amendment defense, that being freedom of speech. But you'll know from Schenck and various other cases, not least Snyder versus Phelps, that the Supreme Court rejects the First Amendment in the use of fighting words, that is, words that are specifically designed to incite a riot. And that's what Trump was doing on January the 6th. What was decided, however, in the district court was that it was not clear whether or not the text of the 14th Amendment extended to the office of the president. It didn't specify presidency in that particular case, in that particular clause. But when that went up to the Colorado Supreme Court, and this is the last step before we move to the federal Supreme Court, the federal appeals court, Supreme Court system, the Supreme Court of Colorado said, and there's a quotation there, "It seems most likely that the presidency is not specifically included because it is so evidently an office." So while the while the 14th Amendment doesn't specify the presidency when it's listing the various offices, it does use office in a general sense, and Colorado Supreme Court said, quite evidently, self-evidently, the presidency is an office of the United States, therefore it is covered by this particular amendment. Now that was a 4-3 decision, so it wasn't unanimous, and we'll come on to the consequences of that in a minute. For the time being, however, Trump is still on the ballot. His disbarment has been paused pending further appeal. The cutoff for the Republican ballot primary ballot in Colorado is the 5th of January. Are we going to get a decision from the Supreme Court before then? Seems highly unlikely. Which means that either Trump is going to be off the ballot, or means that Trump will probably be off the ballot. But that doesn't necessarily mean that they can not include him in that particular exercise. I've heard that they might switch from a primary to a caucus system, and Trump would be allowed to participate in that somehow. But anyway, that's a long way downstream. At the minute, Trump is still on the ballot, but of course, what happens next is that it's going to go to the Supreme Court. And when it goes to the Supreme Court, this dissent is going to be material. That Congress only Congress has the authority to enforce this ban, and only those actually convicted of insurrection can be disbarred. Now, it doesn't say that specifically in the Constitution or in the 14th Amendment. When we do get to the 14th Amendment, we'll get back to that in a second. It does say that Congress can enforce the ban through law, but we'll get to that in a minute. Inevitably, when they were passing these laws, when they were passing these amendments, as with all bits of the Constitution, they're extremely good, but it certainly doesn't mean that they're perfect. So what happens next? Sorry about the small font there, chaps, but I'm sure you can work it out. Trump will appeal the decision. Well, Trump will weaponize the decision. He already has. In fact, he described it as a tyrannical ruling. Other decisions are pending. There are similar cases in Minnesota and New Hampshire. Actually, those were tossed out. But there's one going through Michigan, which is a key swing state, where the initial case was rejected, but that has again gone to appeal. Be interesting to see what that decision comes out, and we're expecting that any time now. This case will inevitably go to SCOTUS, and of course we're looking at SCOTUS. We're looking at a 6-3 court with 6 conservatives, 3 progressives. We've got 3 Trump appointees within that particular court, those being Gorsuch, Kavanaugh, and ACB. That shouldn't matter, but it's hard to see any circumstances in which it won't. Now, as we mentioned earlier, the Constitution on this is not massively helpful. And if we're approaching it from a textualist position or an originalist position, we look at this and there are so many open questions. Effectively, as I said, on the Section 5 says that Congress has the power to enforce the 14th Amendment through legislation. But that doesn't necessarily mean that only Congress can knock Trump off this. The Constitution is whatever you want it to say, but here the detail is very, very light, and there are important consequences there for originalists and for textualists. And of course, on the court we have got large numbers of both of those. Most of them conservatives. And so it's going to be up to them to look into this and identify, what the original intent was, what the actual words mean. And of course, if it's not specified in the Constitution, then the courts get the decision defaults to the states, which is of course where the courts came to in Dobbs versus Jackson. So they're all in favour of state rights when it comes to women's health and various other things. Are they going to be in favour of state rights when it comes to knocking Trump off the ballot? Now, bear that in mind, because that gets really important later. Precedent isn't really helping very much. The last time this was really used was the first time it was used in 1919, where someone was kicked out of Congress for being a socialist. And then in 2022, a New Mexico judge used this case to exclude somebody who had actually been involved in the January 6th, who were physically in the Capitol in January the 6th, to exclude them from office in New Mexico. So this is the last time it's been used, and what we're finding, as with all these things, it kind of defaults to the states to work out how they're going to do it for themselves. So anyway, let's push on. It seems really there are 4 questions in front of the court. The first being, was January the 6th a riot or an insurrection? And the courts have decided that yes, it was. Certainly in this Colorado instance, they have decided that this was an insurrection. They've also decided that Trump was engaged in that he was engaged in the insurrection, and that engagement is certainly not covered by any First Amendment get out. It appears that the court, and certainly in Colorado, has decided that the 14th Amendment does include the office of the presidency. So it then falls to the question, who gets to do the disbarring? If we agree that this was an insurrection, if we agree that Trump was involved, if we agree that the presidency is covered by is an office covered by the 14th Amendment, then the only remaining question is who gets to do any disbarring. So we'll take it as read that it was the 6th, it was an insurrection, that Trump was involved, and that the 14th Amendment is in play. So who then is best placed to assess Trump's suitability for office? And it strikes me, and indeed it seems to strike most people, that there are 3 possible options there: Congress, SCOTUS, and the people. I'm not going to get into the congressional side of things, because we all know that Congress at the minute is a partisan and a highly polarized entity. What I'm more interested in really is what this means for SCOTUS, and it seems to me certainly that SCOTUS is now on a cliff edge. And the important factors here are going to be constitutional theory, democracy, and, as we mentioned earlier, state rights. Now, as we said earlier, when we look at the Constitution is very, very open. It's not immediately clear, or rather the Constitution doesn't specify how this is going to work. In terms of the original intent, well, this was clearly to disbar Confederate officials from holding office. The intent was to exclude people of a certain type from standing or running for office in the United States. So from an originalist position, the use of the 14th Amendment to disbar Trump is entirely valid, because that's what it was there for. If you go to the textualist position, it's hard to see any textualist outcome other than it is possible to use the 14th Amendment to disbar Trump from office. And of course, originalism, you're looking at, Scalia's gone now, but certainly Alito, and to a certain extent Roberts. Textualists, you're looking at Clarence Thomas. So they're backed into a corner here, because the originalist position and the textualist position would seem to indicate that you can use the 14th Amendment to prevent Trump from running in this particular election. So they're in a bit of a bind, our originalists and our textualists. It looks like this is a valid position. Democracy. Well, there are certain problems with the democracy. If we're going to say, right, the people are best placed to judge Trump's suitability for office, well, I'm not going to get into any question about the masses being asses. That's a wholly different point. But let's talk about the flaws in the American electoral system. And this is to do with the way in which the Electoral College works. And the Electoral College, as you will remember, vastly over prioritizes or vastly distorts the outcome of the election. And we certainly saw that in 2000, and perhaps more pertinently, we saw it again in 2016. In both of those instances, the Democrat contender, in the first one Gore, and in the second Clinton, they won the popular vote. In Gore's case by a whisker, in Clinton's case by a significant margin. However, because of the way in which the states in the middle, Wyoming, North Dakota, and so on, are vastly overrepresented in the Electoral College, Trump was able to win, and we saw obviously the decision go to Bush 43 in 2000 by an absolute whisker. So even if we deem the citizens of the United States fit judges of Trump's suitability for office, the way in which the democratic process works in the United States means it's not particularly fair. We can't guarantee that fair outcome, because we saw in 2016 in particular, Clinton winning the popular vote by a big margin, but losing the Electoral College by a significant margin as well. So democracy has its problems in the United States, and that's without even talking about the Senate. So what we seem to be left with is the idea of state rights. Now, SCOTUS is going to be forced to make this decision, and this is by any measure a political decision. Even by deciding not to act, they are effectively making a political decision. And the most likely outcome is that this will be down to state rights. The Constitution doesn't specify how states run their elections, therefore it's up to the states to decide how they run the election. So it might seem like a bit of an odd decision to allow the states to sort this out on a state-by-state basis, but that kind of is how federalism is supposed to work. And the federal government, so the SCOTUS, has tended to give the states the benefit of the doubt. We saw that in Colorado versus Oklahoma. We saw that in Dobbs versus Jackson. We're seeing it with gun laws to a certain extent. But what that could very well lead to is a patchwork of different arrangements on a state-by-state basis. But it's most likely that it's the Democratic states that will disbar Trump from any election. So there's probably not going to be material to the outcome. If we think that the red states are likely to give Trump the benefit of the doubt and allow him to run, well, those are those are states that are going to vote Trump anyway. So even if we do see Trump disbarred from a lot of ballots, it's going to be these red states, so the blue states, where Trump will be disbarred, and they probably weren't going to vote for him anyway. So it's unlikely to have a material impact on the outcome of the election. I think anything could happen between now and then. But this Roberts certainly is very much aware of the precarious nature of the SCOTUS position, and he's got his hands on the detonator there, and it could all go very, very messy. I do think the most likely outcome is that the Supreme Court will give the states the right to decide for themselves, and we will see Trump disbarred from many states. He will weaponize that decision. He will highly unlikely to be disbarred from these big red states in the middle, and so the outcome will be what it was going to be anyway, and this will turn out to be a bit of a nothing burger. Who knows? So that begs the question, really: how is the Supreme Court going to respond to this? Because it's coming its way without a shadow of a doubt. I suppose option one is they could reverse the decision. This would be an active decision. They're overturning the decision of a lower court. They could make that argument on the basis of originalism, that the Constitution was designed to uphold the principle of democracy, and one of the fundamental tenets of democracy is that people should get to decide who their own representatives are. It's not the decision of the courts to make that decision for them. That's one option. And you can think about that as much as you like, really. The next option is, of course, that they could uphold the decision. And this would be judicial restraint. I think you could argue this on the basis of textualism, that there's nothing in the Constitution about it, and so if there's nothing in the Constitution about it, the states get to decide how to run their own elections. And if the states want to disbar Trump because of his role in the insurrection, then that's entirely up to the states. You could also make the argument on the basis of originalism, in that the court or the Constitution does have a series of criteria for presidency. You need to be 35 years of age. You need to have been born in the United States. So this is just another constitutional criteria. It's you shouldn't really have engaged in insurrection against the state. And that whole point of the 14th Amendment was the Constitution saying, look, there are some candidates who are unsuitable for office. And this is just one more criterion that we're putting out there for the states, or rather that candidates have to overcome in order to run for office or to hold office. Either way, I think that the key thing is that this is a political decision. There's no way of dressing it up any other way, and as a result, it's entirely possible that the court could deny certiorari and say, well, look, the Supreme Courts have made their own decision. It's for the states to decide. There's nothing in the Constitution. We're going to let the states go down their own route. And if that leads to a patchwork of different arrangements, then so be it. Because, of course, don't forget that, if there's a patchwork of different arrangements, the chances are Trump's going to win anyway. It's not going to have a material impact. It's entirely conceivable that denying Trump from certain states, largely blue states, will have an immaterial outcome on the election. Perhaps in certain key swing states, that could be very significant. And so, leaving it to the states could be a risky decision. But, it is a powder keg. And the Supreme Court's there. It's got its hands on the detonator. And it's going to have to decide whether or not it pushes it down. And it's going to be fascinating times ahead. I'll try to keep you up to date with that. As things change, this is an evolving situation. We'll find out how these things spin out in the fullness of time, and I'll be back with updates. So please stay tuned. Do let me know if you like the videos. Do let me know if there's anything out there you want me to cover. Do let me know if there's some issues with this issue that you take the issues with this video with which you might and do let me know if there's any issues. This is an evolving situation. I will keep you up to date as things go on. But there you can see it. The Supreme Court is standing with its hand on the detonator. Whether it decides to push it or how far it decides to push it, well, we'll find out in the next few days, weeks, months. It is an evolving situation. I will try to keep you up to date, so stay tuned. If you do have any questions, let me know below the line. That's perfectly great. If there's any issues you want to raise, again, drop them in there. I'm big and bad enough to deal with constructive criticism. And if there's any other topics you'd like me to cover, then please do let me know. But that's it from me. It's been Paul Talks Politics. Like and subscribe. If you do like it, tell your friends. If you don't like it, tell me. And I'll try to see what I can do better next time. Have a very Merry Christmas. It's been great talking to you. See you in the next video. Take care now. Bye.